So I think we all agree here. We all favor more transparency in litigation. We're all against double dipping and abuse of the process. We want to prevent claimants from submitting the same claim twice and being compensated for it. And where I think we may part ways here is singling out asbestos victims for this very different treatment. And I know you've been asked, Mr. Behrens, about this issue, but I'm in favor of transparency and disclosure, which is why I introduced a bipartisan bill with Senator Graham called the Sunshine in Litigation Act. This bill would require information in lawsuit settlements to be kept available for the public, to be disclosed by judges if necessary to protect the public's health and welfare. It's in the public interest that those settlements be disclosed. I assume you're in favor of that.
No, Senator, I'm not, but let me explain why. I think that's a very different situation.
And while you're explaining why, maybe you could also state whether you're in favor of another piece of very important transparency litigation submitted by Senator Durbin. I'm a co-supporter. It's called the READ Act, which would tell the public where asbestos-containing products are located so they can avoid exposure and becoming victims. And I might add, many of those victims are veterans. Some are in this room. They represent disproportionately a part of the population affected by this problem. And I want to thank all the veterans who are here today for their service and ask you to respond as to this transparency issue. And then perhaps I could ask Mr. McKenna to respond as well.
Sure. Senator, with regard
Could you turn your mic on?
Yes. Senator, with regard to the protective order issue, the courts today already have power, if they believe public health or safety is at risk, to lift a protective order. So there is already a mechanism in our rules today for corrective action to be taken by that. Furthermore,
well, there's a mechanism in the law, but it really comes into play only when the parties want it to do so, or alternatively, when the parties ask that it not be. There is no disclosure, correct?
I don't believe that that's true, Senator, because separate from the tort case obligations, we have a robust regulatory system, and many of those products you're talking about, there are independent reporting obligations, for example, to CPSC, to NHTSA, and so on, so that the information is not being suppressed in a way that's going to impact public health. There are other mechanisms. It can come out in the civil cases, obviously. There's no protective order if a judge believes it's not warranted. And furthermore, the information is given to the agencies that are charged with handling those situations.
So your response is that we ought to rely on the regulatory agencies to protect the public interest, but secrecy is fine in the court system.
That was not my testimony. My testimony was that if there is something in the tort system that in a case that comes out that affects public health or safety, and the judge believes that that should be made public, the judge first can decide not to grant the protective order. It comes from the court. And second of all, the judge can lift the protective order if he believes that it's in the public interest of doing so.
Well, the same logic that you're applying here would also argue that there are other means to seek information from claimants about their prior claims or their prior awards without going through a process such as the FACT Act contemplates.
I'd have to disagree respectfully, Senator, because as Mr. Inselbuck said, at the plaintiff's depositions, they don't know. And they will say, I don't know. And, but the information is available. Their lawyers have it. That's how the claim forms eventually get filed.
And
the information
companies
is available.
routinely tell the regulatory agencies, we don't know, or we didn't know. Witness GM, the defective ignition switch. Witness Takata, exploding airbags. Those are two only very recent examples. The regulatory agencies are overburdened, understaffed, relying on them instead of the court process is really, I think, an inadequate approach. And so I hope that you will think about supporting the Sunshine in Litigation Act and the READ Act. I certainly want to address this issue of possible abuse in asbestos claims, although I have yet to be convinced that there is significant abuse or that the abuse warrants the approach that is taken under the FACT Act. My time has expired. I thank the chairman.